Blog Talk Radio.
Hello, test. Hey, everyone, and welcome to episode number 3 of Land of the Obots. We're going to be here most every Tuesday night. We'll be here this week and next week, and then I think I'm off until the 7th of July, but you'll get the updates. Welcome, everyone. I hope you're having a great week. And by the way, I asked last week if anyone knew the title of that piece of music, and I didn't have any tickers on it. There will be a Golden Burfer Award if anyone can come up with the title and what it means. So again, welcome to our third little show here. I'm starting a new feature this week. And toying around with the title, it's going to be the Burfer Week in Review, or Burfers in the News. So without further ado, we'll get into the first segment. This is the Burfers in the News. Okay, that's our little lead-in to the news there, and some of you old-timers might recognize where that came from. Well, this week for the Burfers, it was a big week, let me tell you. I don't think I can fit everything in. The first item in the category I've titled Burfers Under Attack. Well, folks, it's finally happened. The Burfers have had such an impact nationwide that Obama is striking back. He's unleashed the Obots, and they're wreaking just holy havoc on the Burfers. First, and this story is Dateline, Mission Viejo, California. We hear from Dr. Orly Tates that both her car and Yosef's car have been sabotaged. We don't have all the details yet, but Orly did file a police report. She posted that on her blog. And what we understand happened is in Yosef's car, wouldn't run, ran poorly. Some kind of idiot light came on, we're not sure. And when they took it in, there was a fuse missing. Couldn't be found at all. And that was just a dastardly attack on Yosef's car. And wouldn't you know it, the same day, Worley's car began running poorly, and some evil Obot had removed a clamp from an emission hose in the engine. And thank God she found it, or the entire car could have burst into flames at any minute. So that's the news from the Worley front of the birthers under attack. We also had another threat. Believe it or not, those dastardly Obots have struck again. This story is Dateline, Wellington, Texas. And our good old friend Ed Hale posted this on his blog the other day. This is from Mr. Hale. I received this email from Jim Bott, who told me that if I go on with the show tonight, he will have a team of U.S. Marshal, not plural and also misspelled, by the way, here to arrest. Read for yourself. And read is improperly capitalized, and yourself is misspelled. And I guess he's quoting the email here. He doesn't put quotes, but you have to infer that from Ed's writing. And Jim Bott said this to Ed: how is Pigeon qualified to confirm anything? Oh, and your little fake outrage and hurt feelings regarding me calling you out for letting your dog die is really fun. Sorry, Ed, but you chose to post that audio and whine on the net. You exploited your dog for personal gain, not me. So then if you want to act like a little child, so be it. However, at least be honest with your listeners and tell them the truth. You're scared of me, which is why you won't take my calls anymore. And Jim Bott goes on, hey, did you see this? Remember internet radio host Hal Turner? And he quotes a web link here. We've busted him for inciting violence against government officials. I can have a team of U.S. Marshals in Wellington before sundown. And by the way, Jim Bott spells marshals correctly. I can have a team of U.S. Marshals in Wellington before sundown if needed. Do I need to do that, Ed? Well, of course, Ed's followers all chime in about how Ed's under attack and he should hire bodyguards. Ditto. So it was a terrible week, and the Obots were just wreaking havoc, as I said, on the Burfers. Now, the final item for Burfers in the news comes Dateline Honolulu. And this has nothing to do with, this is an attack. It's basically an attack on their integrity and kind of knocks out the underpinnings of one of their pillars of Obama's ineligibility. This was a story that appeared in a Honolulu Star Bulletin newspaper in a small column called the Kokua Line by June Watanabe. That's a great name. I like that. Anyway, it starts out, this was posted on Saturday and published, and Ms. Watanabe says, question, what is the state's policy for issuing a certification of live birth versus a certificate of live birth? My first, second, and fourth children receive certificates, but my third and fifth children receive certification. Why the difference? The certificate contains more information, such as the name of the hospital, certifier's name and title, attendance name and title, etc. The certification has only the child's name, date, time of birth, sex, island, county of birth, mother's maiden name, mother's race, father's name, and father's race. Why doesn't the state just issue certificates? When did it stop issuing certificates? Is it possible to obtain certificates for my third and fifth children? And this is the answer from the writer June Watanabe. Answer, no, you can't obtain a certificate of live birth anymore. The State Department of Health no longer issues copies of paper birth certificates as was done in the past, said spokeswoman Janice Okubo. The department only issues certifications of live birth, and that is the official birth certificate issued by the state of Hawaii, she said, and it's only available in electronic form. Okubo explained that the health department went paperless in 2001. Quote, at that time, all information for births from 1908 on was put into electronic files for consistent reporting, she said. Information about births is transferred electronically from hospitals to the department. The electronic record of the birth is what the health department, in parentheses, now keeps on file in order to provide same-day certified copies at our help window for most requests, Akubo said. Asked for more information about the short form versus long form birth documents, Akubo said the health department does not have a short form or long form birth certificate. The birth certificate form has been modified over the years and decades to conform to national standards and models, she said. Akubo also emphasized that the certification form contains all the information needed by all federal government agencies for transactions requiring a birth certificate. And I think that's worth repeating. Akubo also emphasized that the certification form contains all the information needed by all federal government agencies for transactions requiring birth certificates. She added that the U.S. Supreme Court has recognized the state's current certification of live birth as an official birth certificate meeting all federal and other requirements. And I'll repeat that again, all federal and other requirements. So I won't read the rest of the article. That's about half of it. But that was very interesting. And I knew when I read this that this would put the birthers in a real tizzy and in a pinch, but it did. It did as I expected, and it's been mentioned on several of the blogs. Now, this isn't new information to any of us who have been following this story, this entire birther movement. It's not news that the head of the Department of Health, Dr. Fukino, and I think the same spokesperson, Mrs. Akubo, said essentially the same thing last year, that this is what we do, this is what we issue, and there are lots of reasons for doing that. If you imagine dealing with old records, and I don't know what the population of Hawaii is, but potentially millions of records, if you consider going back to 1908, it certainly makes sense and saves money to put the key data in electronic format. They've decided exactly what goes on this certification, and it carries all the legal weight of this, quote, long-form birth certificate, which people could have gotten, and probably many Hawaiians still have, as do people in other states. But the idea that this certification doesn't carry the same legal weight as a birth certificate is just silly, and we know it's silly. So check see if we have any callers there that want to talk about any of those stories. There are other things going on. I think there was some news today, actually just happened today or yesterday, in the big battle of the birthers between Phil Berg and Orly Tates in that lawsuit. There were some filings on the Berg side. By the way, the call-in number is 347-324-5546. Area 347-324-5546. If you'd like to call in and discuss any of those stories or anything else related to politics, Obama eligibility, we'll be happy to talk about anything in the world. Just be polite, state your case clearly, and won't cut you off, even if you disagree. No threats or profanity are going to be allowed, and we won't allow you to just ramble on either. We're only here for 90 minutes, and we want to give other people a chance. So that is our new feature, Birthers in the News. Okay. With a decent audio mixer program, I could do nice fade in and fade outs, but I'm still investigating that. Actually, I found this weekend there are some pretty decent freeware programs out there that you could produce some pretty darn professional sounding content. If I only had time, I can figure out how to do them. But we'll work on that. If we keep doing this, and I'll have to see. Probably get tired of talking about further conspiracy theories after a few weeks, but boy, they do provide a lot of entertainment. Okay, we have a caller. Let me put you on the air here.
Georgetown JD.
Hello.
Georgetown JD.
Good evening. How are you?
I'm doing very well. How are you doing?
Well, I'm having a great week. It's kind of hot where I am. I'm in the South this week on business, and it's pretty darn hot down here. So what would you like to talk about this evening?
Well, it has been an exciting week, and I want to talk about any of these topics. I've been reading the pleadings that have been filed in the Liberia versus Tates action. I think you alluded to that a few minutes ago. And speaking as an attorney, they were interesting. I'll say that. I would probably not put my signature on those kinds of pleadings. They're a bit of a rambling mess, but they are interesting.
Maybe for the listeners, you could. I know a lot of the people out there know what's going on, but just in case we have some people who aren't following this closely, maybe give us a little background on that lawsuit and where it stands.
Sure. Well, for those who have been following this, you know that Phil Berg and several co-plaintiffs have sued Orly Tates and Ed Hale and a private investigator out in California who feeds Orly information, a guy by the name of Neil Sankey and his investigations firm, Sankey Investigations. And I think it's Linda Starr, or Linda Belcher, who used to post over at Obama Crimes as Linda Starr. As you know, they've all been sued for a number of claims. It's a little unclear what all the claims are and against which claims are asserted against which defendant, but kind of the gist of it is that there's a lot of slander, defamation, invasion of privacy, or false light claims going back and forth between all these different parties. And what happened from you have to kind of read these very, very generically because none of the parties are very good at drafting legal documents, and that includes the attorneys who are involved. But several of the defendants apparently have defaulted by not answering the suit in time. And, of course, the most conspicuous of these is the online lawyer herself, Orly Tates. Apparently what she did is instead of electronically filing, which is something that's a requirement of the court there, it's filed in the Eastern District of Pennsylvania Federal District Court, which has a local rule requiring electronic filing or consent by the clerk of the court to opt out of electronic filing. Orly apparently doesn't know much about electronic filing because she didn't file her response. She instead sent it to a private residence in Pennsylvania. Apparently this person had agreed to file this for her. Perhaps he runs a process servers business or something like that. But the bottom line is that she filed her answer and a motion to dismiss 2 days late. And under the federal rules, that's a default. So, of course, Berg pounced right on that. He filed for what they call an entry of default, which is simply an entry in the docket by the clerk making note that an answer was not timely filed. And that sets it up so he can go to the court and file what's called a motion for default judgment, which would then allow the court to enter a judgment against Orly, and she also failed to answer on behalf of the Defend Our Freedoms Foundation, so there would be a default judgment against them as well. What's left to be done after that would be a determination of damages. There are ways that these can be put aside. You can move to set aside the default, and apparently Orly has tried to do that, but because she's less than articulate in the English language at least, she filed some kind of a pleading which she tries to rationalize why she should be able to go forward with the case. From a legal standpoint, from my view as an attorney who's been practicing 24 years, it's not going to do the trick. What you have to do in those kind of circumstances is basically fall on a sword. The standard for having a default set aside is what they call excusable neglect. And she really hasn't offered any reasons, because typically Orly does not accept blame for anything that she does. So she has not done what's necessary, which is to set forth facts and law which would constitute excusable neglect for filing 2 days late. She goes on and on about a lot of different things, and also takes the opportunity to introduce yet more scandalous material by filing it with the court, just compounding the problem that got her there in the first place. So yesterday, Berg filed additional papers to go ahead and move forward on the default, and also a motion to strike, which is something that's allowed under the federal rules, that basically asks the court to disregard these additional papers that she filed. What she does is she takes one of her dossiers and she slaps an exhibit or attachment label, and she attaches it to everything she files. And since that is really not relevant to default, Berg has moved under Rule 12F of the federal rules and asked for the court to strike that, which is basically just to throw that out. And while his pleading is less than a model of clarity, I think the gist of it is that he's kind of got her. He's kind of got her between the horns there.
Okay. This is Georgetown JD, right?
Yes.
I didn't get the name down. Okay.
Yes.
Gee, thanks for calling in. To have a real lawyer is a big plus. And I've got some questions. First of all, how common is it that in a civil case like this, I guess from what I understand, Berg is asking for a huge amount of damages. It's in the multi-million dollars. But how rare is it for someone to miss a filing deadline like this? Does that happen very often?
It does happen often. It happens more often when someone is representing themselves, and that's the case with Orly. However, in most of these cases, the person who is appearing in court and filing these papers on their own and missing deadlines is not an attorney. So Orly really, I think, has no excuse. She has certainly supposedly the legal training to be able to look at the federal rules, and in her filing, she evidenced that she knew what her deadline was. She knew that it was on May 26th. She acknowledges that. So she's going to have a little bit more difficult time than another litigant might have. But it actually happens more frequently than you would imagine.
Well, I guess the next question, and it sounds like if someone were not an attorney, the judge would probably tend to be more forgiving. But how forgiving do judges tend to be in cases like this, where someone doesn't follow the rules, didn't file electronically like the rules clearly state, and then missed the deadline?
Well, that's going to be kind of a case-by-case basis. It's hard to predict, but you're right. The judges tend to be more forgiving when you are a pro se litigant. You're not familiar with the rules, or you're not familiar with the electronic filing process. And generally, the sooner you file after your deadline, the more likely it is that the court is going to be forgiving. So an ordinary litigant who misses the deadline by 48 hours is probably not going to have much of a problem. An attorney, though, I mean, if an attorney did this for a client, it would be malpractice. It's just unexcusable for an attorney.
I see Orly's next lawsuit. It's going to be Tates v. Tate. She'll sue herself, and there'll be another dossier published out there. Okay, well, that's interesting. All right, let's say Berg's motion for default judgment is successful. Then, from what I understand, you're saying it would move into a damage phase, right, where he would still have to prove damages.
Yes, there's some instances when the court will just grant you the damages that you've requested, but that generally is going to be in, for instance, a contract matter where there was already a sum certain. is established by the contract itself. So there's really no controversy as to how much should be awarded. I've been able to obtain default judgments, and I didn't have to go in what they call prove up the damages because it was based on a contract. The contract set forth the exact amount, or the statute would say, well, whatever the contract amount is, there's you get triple damages, and so it's a mathematical calculation. In this particular case, though, where I think he's asking for multi-millions of dollars, and it's based on what are really tort type of offenses or offensive conduct, the court is not going to grant him a default judgment without making him prove up damages. And so you have to recall that in each of these plaintiffs is going to have to come into court, and they will hold an evidentiary hearing, and they have to put on evidence of how much they've been damaged and how you go about quantifying that. Now that'll be an interesting phase because the torts that have been alleged are basically slander or libel, invasion, or false portraying one in a false light, which is a form of it's a tort in which even a truthful statement can be culpable because it portrays the plaintiff in a false light or in a negative context. And that may be what is going to have to be Lisa Liberi's. It appears that that's Lisa Liberi's claim, that yes, maybe someone does have, a criminal record, and it is true that this person in the past was pled guilty to some kind of an offense, yet the way you are portraying that person, the way you are broadcasting this across the nation, the way you are implying that as a result of that past conduct that makes that person presently a criminal person or likely to be, a criminal, portrays a false light, and that is actionable. The way you prove damages, though, what you have to prove for these, though, is that you have to come up with a quantification. What was your reputation before these statements were made, and how much in dollar terms has your life been affected? So you have to demonstrate your good reputation in the community before and the reputation in the community after. And frequently these kinds of awards, because it's very difficult to calculate how that impacts someone financially, frequently the award is $1. Now, there can be instances where they award punitive damages, and that is if the statements were knowingly rather than negligently made, then that opens it up for punitive damages. And I think that's kind of where Berg is going to try to go.
Oh, that's interesting. That's something I didn't know. So let's say Joe has a criminal record, and he was busted for marijuana or something, just to pick something. He moves into a new town, and Jack, who turns out doesn't like Joe, finds out that he has a criminal record, and he calls up Joe's employer and says, "Hey, do you know Joe had a criminal record?" And I don't know what, maybe Joe was truthful or maybe he wasn't, but let's say he spreads it all over the community, and Joe becomes a pariah. So you're saying that even though what Jack was saying about the criminal record is true, if he is using it to besmirch Joe's reputation, then there may be actionable damages. I don't think a lot of people know that, if I'm right.
There may be, and of course these are state law claims, so it's going to vary from state to state whether that is a recognized claim, number one, and number two, what are the elements that you have to demonstrate. A little better case in that instance would be not just the fact, because the fact that he has a conviction is a matter of public record, although it may not be widely known. However, let's say that you make the statement that Joe has in the past been convicted of possession of marijuana, and it's published in such a way to suggest that he continues that kind of conduct. You don't come right out and say it, but you suggest it. Now, there's the false light. The fact that a person has this event in the past and the implication that he still is a bad person. But false light is a useful tort because in, I think it was in, I'm going to have to reach back here. I think it was in the 1960s. There was a case called New York Times versus Sullivan, and it was a defamation case. And it set the standard for proof, which is a bit higher if one is in the public eye or has thrust themselves in the public eye as a celebrity or as a politician. And the plaintiff, who is the person who's been harmed, has to prove basically that the defendant knowingly made or maliciously made a false statement. For you and me, who are not known widely, we just have to demonstrate that the person who made the defamatory statement about us was negligent, that they really should have used more care in determining what the fact was or in the truth or falsity of their statement before they made it. So what developed after that is that celebrities had a more difficult time demonstrating defamation because they are in the public eye and they're expected to have a bit of a thicker skin and to be able to tolerate a certain amount of false statement. However, they've been very successful, and I haven't looked at the law in California, but I imagine that that's where it's been fairly well developed. They've been fairly successful in obtaining judgments against persons for this false light or invasion of privacy tort. That would be interesting because Orly, among other things, has sort of suggested that venue in this particular case ought to be moved to California or Texas. And she actually may be doing herself a disfavor because the law may be far more developed in California as a result.
Now, I guess one thing that confused me is this filed in, was this suit filed in federal court or in Pennsylvania court?
It's filed in the Federal District Court of Pennsylvania, the Eastern District of Pennsylvania. Pennsylvania is divided into 3 federal districts for the court. So this is the Eastern District of Pennsylvania. It's headquartered in Philadelphia. However, in a federal court, when you have diversity of citizenship, that means that your plaintiffs and your defendants are in different states, you may assert state law claims. You're not necessarily tied to federal questions, and that's how this arises. The case is based upon, among other things, diversity, and therefore, in federal court, you may say, under Pennsylvania law, under California law, under Texas law, and they're not limited to Pennsylvania law either. For instance, you could be suing a California defendant and saying, you acted in California, and under California law, the standard for establishing defamation or false light is X, Y, and Z. And the court, under a long line of cases, has a doctrine where they will apply the state law as they interpret it or understand the state courts would do. They look to the law of the highest court of the state. So, for instance, they would look to the law that's been established by the Supreme Court of Pennsylvania or the California Supreme Court to determine what is the standard to apply to that cause of action.
Interesting. So let's say the standards are different. Which one would be applied? Would it be California where Orly lives or Pennsylvania where Berg lives? How would they make that determination? Which standard?
Well, the parties are going to have to brief that question if it comes up. That is, there's a whole body of law called choice of law or conflict of law, and there are instances when the law of one state is different than the law of another state, and that itself then becomes an issue in the litigation as to which state's law really applies. And each state has usually a statute that indicates, what are the factors to determine whether we're going to apply our own law, and what are the factors that would determine whether we would apply the law of another state. And among those considerations would be where the act took place, where the plaintiff resides or is domiciled, and where the defendant is domiciled. For instance, in a case that I have, we looked at that, and when we briefed the issue in a case that's pending in the federal courts of New York, and we laid out for the court why we thought New York law governed over Delaware law. And we liked the New York law. It was more favorable to us. And in that particular case, it gave us a longer statute of limitations. And so we were able to persuade the court that based on the 3 factors that New York looks at, we met 2 of those factors. And the court agreed with us. But that is something that will have to be briefed if the question arises. Now, the question I have is whether either of these parties recognizes that as an issue. And my money is on that Orly doesn't even understand that concept. I don't know if Berg does.
Yeah, I think I'm on your side on that one. So we really haven't gotten far enough along where that would be an issue, but a diligent attorney would be researching those sort of things right now, and or maybe it would have even been included in the original lawsuit that was filed by Berg. Is that correct? Would that be a place you would include?
More often where you would include that is you would raise that in your motion for dismissal. And so Orly has filed motion to dismiss, and by that I think she really means a motion for change of venue. So it's kind of, her terminology is not very precise. Normally when you file a motion to dismiss seeking grounds, you set forth the grounds on which you want the court to dismiss the complaint, and you normally file a brief with that. She kind of mixes and mashes everything together, so it's and then of course her motion, as I just discussed before, didn't really address what her motion was all about. She attached all this stuff about Lisa Liberi and didn't really get to the heart of the matter. But that is where it's usually raised, because that is your first shot to convince the court as in some way to the merits of your case. It's a way to poison the well, so to speak, to let the court have a glimpse of your case. And it's really up to the defendant to throw as many of these issues out as possible and muddy up the waters, and it's up to the plaintiff really to clarify for the court why the case should proceed.
Yeah. Well, it's going to be fun. We'll all be watching. It's just additional entertainment, I guess. We all say that, but gosh, this, when you're talking about multi-million-dollar lawsuits, it really is serious, and it's. I guess when you look at the characters involved, we shouldn't be surprised, because if you look at the other cases they filed against Obama and their writings on blogs, they all live in somewhat of a, let's say, a world of non-reality, just to play on my name. And I'm not surprised that it's just a strange cast of characters. I probably could say more, but you don't have to read very much to figure out that these people are not really well grounded in reality.
No, they're not, and they're not very well grounded in law either. And that's what makes it really amusing for those of us who are in the legal profession. And surprisingly, a lot of the people I know on some of the blogs that I write on, they're laypersons, and they seem to be able to grasp these issues. These are not, some of these are very complicated issues, and some of them are very simple issues, but I've found that when I'm asked a question, and I will do my best to try to educate some of these non-lawyers, they, at least on the non-birther side, on the Obots side, they readily pick up on the concept, and then I watch some of these people develop, and on their own they're able to express these arguments and make quite convincing arguments.
Okay. Well, this leads very well into my next topic I had tonight, but I'm going to take a couple-minute break, and I'll give the number out again. If anyone would like to call, the number is 347-324-5546. I think you can also click on the Blog Talk link and use voice over IP if you have that set up on your computer if you don't want to pay the long distance charge. But it's 347-324-5546. And if you want to hang on, Georgetown JD, and listen, you're certainly welcome, and comment on anything else. You're certainly welcome to stay. But I'll be back in just a couple minutes.
guess a landing spot on the dark side of the moon. I suppose she could guess a cave.
Okay, we're back, and we have another caller. Caller number 2, go ahead. You're on the air. Hold on. Hello, caller number 2, 505, go ahead.
Hello, this is Bob.
Hello.
Calling from New
Hi.
Mexico. How are you?
I'm sorry, what was it? You were calling from where?
New Mexico.
I'm having a little trouble hearing you. Go ahead again.
I'm sorry, from New Mexico.
Oh, okay. Welcome. New Mexico, welcome aboard. Welcome to the show. What would you like to talk about?
I just tuned in a few minutes ago and was listening to the talk about the cases with the lady that was on the line.
Yep. Well, let me put
enjoyed that.
Yep. I think Georgetown JD is still there.
Yeah, I'm still here.
Oh, hi. How are you?
Hi. How are you doing? How's everything going in New Mexico?
Everything's going great. Beautiful weather.
That's a great state. That's one of the states on my list I haven't seen yet. I've been to Arizona a few times. Utah and Colorado and Texas. I've been all around New Mexico, but I haven't made that state yet.
Well, you need to stop in here sometime if you're all around it. Nice place.
Well, it's on my list. It's on my list of places to see. Yeah, any comments on what we've been talking about tonight?
I only caught the last couple of minutes of what you were talking about earlier, so I probably shouldn't jump in the middle of that. I thought maybe since I was in New Mexico, I might tell you a little bit about Paralegal New Mexico, who seems to be connected to the birthers somehow. Man,
sure.
Whose last name is Daneman. Leonard Damon, I believe, is his name. Goes by the moniker Paralegal NM.
He's that guy who's doing ghostwriting for Orly, isn't he?
It would appear so. That's you can always tell when somebody's written slightly better than she has that it's someone else. And
yeah,
I suspect it's Mr. Damon.
I suspect, and again, this is very subjective, but you sometimes see that things all of a sudden make a lot more sense than they do at other times. So go ahead, caller.
Yeah, I just thought when he first came into the picture, because I saw the moniker NM, and so I did my Google search, and sure enough, found out that he is here in New Mexico. He's actually a photographer, has a studio in downtown Albuquerque. Actually, from what's on his walls, he's a very good photographer. Much better than he is a paralegal, in my humble opinion. I actually got curious, went down to his shop one day, looked around, and As I say, the photography was very nice. He happened to be there, and kind of your basic pipe-smoking, deep-thinking-looking guy. Was pleasant, but I also then found another blog, also called Paralegal NM, and it happened to lead to a real paralegal in New Mexico whom I happen to know, and so I contacted her and asked her, did she know someone else had her same blog name, and she said she didn't know about Mr. Daneman, but that it's not the first time somebody had stolen her name, whether evidently she's never done anything about it. But I did a little more research, found out that Mr. Daneman is not a certified paralegal in the state of New Mexico. He claims that he has gone through a couple of years of law school, and rather than just saying he didn't finish, he says he was prevented from finishing, and I've never understood what that meant, but at least that's what he claims. And he does.
Did you say prevented from finishing?
That's what he says. He's
okay.
If you go on his
I want
blog,
to make sure I heard that right.
Read his little bio. He says, I was prevented from finishing law school. I have no idea what that means.
Okay.
Because he goes no farther. So he plies his paralegal trade on the basis that he has a couple of years of law school behind him. And pretty much that's the story of Mr. Daneman. But if anybody does go to Paralegal NM blog, they should be aware, to be sure, if they're looking for the birther Daneman or birther Paralegal NM, that they make sure it's Mr. Daneman's blog and not a young lady whose last name happens to be Schiller. She is a real certified paralegal in New Mexico.
You know, that seems to be a common theme among the birthers, is that they feel quite free to take over the trade names or the blogs of other people. I know that there's an instance of a business in Northern California, and it's being used illegally by some birther who's posting on several sites and has basically co-opted this business's website.
I see someone.
They don't seem to have any kind of respect for intellectual property.
Yeah. Someone in the chat's telling me to speak up. Are you still having trouble hearing me?
I'm hearing you okay in New Mexico, but you're not quite as loud as Georgetown JD is, but I can hear you okay.
Yeah, I hear her real well too. I happen to
probably the phones and the connections.
Yeah, she has a great voice, so very pleasant to listen to.
Yes, very intelligent lady too.
Well, thank you. Thank you.
That's interesting.
Most of the if you see me around on sites, you would know me as Realist. Is who I'm.
Okay. Okay. We've seen you. We've seen a lot of good writing things you've posted.
Well, thank you. That's really about the entire story I know about Mr. Daneman. Kind of there's not much about him except what he writes. So.
Well, and of course, we don't want to imply there's anything evil going on there, except
Of course not.
Using someone else's blog name is probably not good form naturally, but I don't think there's anything illegal about it. But there's nothing wrong with having help writing for you, because Lord knows Orly needs help writing. So absolutely, she needs all the help she can get. And I thought if any of you listened to Plains Radio a couple of weeks ago, we thought Orly was soliciting help from Allison, the caller Allison on there, but I don't know what's happened, but she certainly seemed interested in getting help. And you can just look at the quality of the blog.
Although today she made a comment on her blog when somebody mentioned Allison, that she had never heard of Allison and has no idea who she is. So interesting.
Oh, that's interesting. I'll bet we have a listener out there who has that all recorded, that entire conversation. I think Orly better rethink her denial on that one. But doesn't seem to I don't know. Nothing seems to bother that lady. She's an irresistible force. She just keeps plowing on down the birther highway, and I don't think much is going to stop her. But
I also wanted to tell you that I'm glad to know this show is up and going and alive. I think it's a great idea, and I hope it can continue.
Okay. Well, I think it will. Like I said, I really got frustrated. I got involved going in the chat room that a lot of us visit, and while we were listening to these just poorly done, lying radio shows, and you know the ones I'm talking about. There are 3 or 4 of them. It's just they lie with almost every other word. Their arguments are poorly thought out. They treat anyone who in their chat rooms or in the calls doesn't agree with them very with great disdain, and well, we all know how it is. And I just said, 2 things sort of pushed me into this. I knew this couldn't be that hard to do, so I investigated Blog Talk Radio, and there's a lot of things about Blog Talk I don't like, but the thing I do like is it's absolutely free. I can call in. All it takes is the minutes to call in to a long distance number, and there are ways around that. Things like Skype, which I'm using. It provides very crude tools for producing a radio show, but you can get them on the air. And one thing it shows me is that, and I was going to talk about this last week, but we got into such a good conversation with a couple of callers last week, I didn't cover everything, is just how little Ed Hale has to be spending on his operation of Plains Radio. First of all,
but he needed $5,000 for the attorney just to keep the radio on.
That's right. He
couldn't pay his phone bill.
Right. He couldn't pay that much for phones. I mean, people are spending money to call in. Like I said, but his over-the-air radio station is not licensed. I don't think he never mentions that. I sent him an email and asked him how much power he runs, because he uses the call letters KPRN on his blog, but that is not a licensed radio station. I did a search of the FCC database, and one of the other posters on the blog tipped me off on this too. That radio station doesn't exist in Wellington, Texas. The only KPRN in the FCC database is an FM public radio station in Grand Junction, Colorado. So there's nothing wrong with what he's doing as long as he's limited to 100 milliwatts. The FCC allows, under Part 15, anyone to run their own radio station, but the power is limited to 100 milliwatts. Now, on AM, 100 milliwatts on a good night might get a mile over clear ground, and that's with a good receiver in the best conditions. It's typically 100 milliwatts is what a good example would be if you have XM radio and it's rebroadcast, so you can pick it up on FM in your car radio. There's a limit on those. Part 15 of the FCC governs those type radio stations. So his radio station is essentially make-believe. It's something that a 9-year-old kid with a kit from Radio Shack could do to broadcast with 100 milliwatts. And then the rest of it, he's using Shoutcast, I think, for his publishing his online show, and he's probably renting web space. Even at the outside, I would say he's spending no more than a few $100s a month to run the website, but that's neither here nor there. But this idea that he needs X number of $1,000s to keep Plains Radio on the air is just, I don't think, supportable by any of the facts.
So Studio A is really the kitchen, and Studio B is the den.
That's exactly right. I suspect they're working from 2 computers, logging into the website or calling in. There just can't be much to it. And if you look at what I'm impressed with what he does. He broadcasts those old time radio shows to fill the airtime. So he must have a setup on his computer to feed that audio in. But what he's doing is, to call what he's doing a big production or a radio station is just stretching the truth until the breaking point.
So what you're saying, it'd be a little hard to reach those millions of listeners he talks about every night.
Well, absolutely, because 100 milliwatts is not going to get off his farm if he lives on a farm. I guarantee you that. He might go pick it up on his tractor until he gets out to the end of the field, and that's about it. That's literally nothing. Just to give you an idea, as the old Citizens band license or handy talkie that you can buy will broadcast. Most of those I think are limited to 5 watts. You can go out now and get an amateur license and run a full 1,000 watts, but you have to take a test and be licensed to do that, operate within certain frequencies, and of course you can't be into commercial broadcasting either. So he's operating under, it's not really a loophole, it's just it's like a hobby type station that you'd set up to broadcast around your house, call a Part 15 station. So it's that part of it. What he's doing is perfectly legal. It's just the idea that it costs thousands of dollars to run is ridiculous.
Well, I think we all probably had that part figured out.
Okay. Something I wanted to talk about, and I titled this little topic, Occam's Razor or the Law of Parsimony. And I want to talk in general about how these birthers go about making their claims and supporting their claims on the blogs. Well, first of all, they're making an extraordinary claim to begin with. They're claiming first that Barack Obama is lying about being born in Hawaii, and that a lot of people are in on this, and that since he's lying, since they claim he wasn't born in Hawaii, he's not a natural-born citizen, and that he's taking this huge risk of that being discovered to have run for president. Now, to support that, here are some of the things you have to believe. First of all, you have to believe that the president himself is lying. Most of us don't. Most of us, and I think most Americans, think he's a pretty darn honest guy. He's certainly shown no propensity to lie. I think he's been pretty honest, throughout his public career anyway, from what we've seen. And I can't see any actions he's taken to believe that he's being less than truthful on this. You also have to believe that the document that was published on the internet is forged, that impartial organizations like Fact Check are in on the swindle. You have to believe that the officials at the Department of Health in Hawaii are in on the scam. You have to believe that his grandmother or the hospitals were in on the scam in 1961 when contemporary birth announcements were published. So they're making this extraordinary claim. And in my book, extraordinary claims require extraordinary evidence to prove. I'm sure many of you are familiar with this term, but basically Occam's razor says that for any consequence or result, the most likely explanation is the simplest one. And the simplest explanation is that we take at face value he was born in Hawaii and he isn't lying, rather than all these convoluted things happening. But one thing I've seen the birthers do is, they have this whole set of things that would have to happen for this conspiracy to be true. They take one thing and pick it apart and then say, aha, I've picked this little thing apart, which they almost never have, and therefore this extraordinary claim that I'm making is true. Someone like this Polaric, like the fake guy on the internet, and I call him fake because he claims credentials as a document expert, but he posts on the internet without using his real name and makes these extraordinary claims that he can tell that this document is forged merely from examining a JPEG published on the internet, which I think any document expert, to me, any professional would not make that sort of claim. But anyway, he gets on and makes that claim that the document that's posted isn't true, but yet they ignore all the other body of evidence. So it's just that, okay, if I can disprove that one thing, then I can bring down this entire body of evidence. Well, it doesn't work that way when you're making an extraordinary claim. You can't just find it. Another example is this article that I read early from the quotes from the spokesperson for the Department of Health. You know, they pick that apart on the blogs like it's a legal document. You know, she made a statement that birth certificates are only available electronically. Well, I've heard that picked apart. Well, the one he displayed wasn't electronic, it was printed. Well, I think any reasonable person would know what she meant was the data is stored electronically, and when you need a certified copy, we print a copy, we emboss it with the seal, and that's the paper copy, but the data behind that paper copy is electronic. So
they've even gone a lot further than that with that. I've even read where some of them have made claims that it should have been typed in 1961, and since that one's obviously printed from a laser, that it can't be real, which is an absolute ridiculous thing to say.
Well, and then they spread these. There are two lies I've heard spread over and over and over, and you see people post on blogs that obviously believe them. Number one is that I hear the story, you couldn't get a passport or you couldn't even join a little league with the birth certificate that was produced. Well, that's just totally, that statement's made in ignorance, because that is a legal document. And if you look at the passport site, they leave some wiggle room. But basically, that document is a valid birth certificate and could be used to get a passport. Now, if they suspected I expect the reason that we leave wiggle room in the wording is that if they suspect someone is being phony, it gives them the right to go back and ask for more. But I will bet you in 99 cases out of 100 that would be accepted for proof of anything. And as the lady said, this sort of birth certificate is valid for anything. So again, they completely ignore the Occam's razor, put together these convoluted stories, you know, that Obama is, this vast conspiracy is going on, and they just don't think through what it would actually take to pull something like that off. And again, it's going into the situation with your mind made up. They hate the guy, therefore they're willing to believe this tall tale, convoluted conspiracy theory based on no evidence.
Well, they go way out there on this birth certificate thing. There was a post, I believe it was from Orly's, the other day. Some lady said she took her kid to play miniature golf, and they had some kind of special going. If you were under a certain age, you got to play free. And she had to whoop out her daughter's original birth certificate so she could get the discount. These people claim, A, it's ridiculous that she was walking around with any birth certificate in her purse. B, for any of these people to say they have their original birth certificate is absolute nonsense. Nobody has their original birth certificate. And to claim you got to have it to play Little League and so on and so forth is nonsense. I had to apply just recently, a month or so ago, for security clearance with the Department of Justice and the Department of Homeland Security to do a particular job that I had been hired to do, and I had to get clearance. All I have is a certified copy of my birth certificate, and it was fine for the Department of Homeland Security and the Department of Justice, so I suspect it would be okay for miniature golf as well.
Well, you know, what they don't want to confront or they don't want to admit is that this not only is a valid document for purposes of obtaining a passport or Social Security, but what's really important is that you have to keep in mind that this is considered a self-authenticating document under the Federal Rules of Evidence, and they're crying how much they want to get into court, but then what they don't want to do is respect court rules. Rule 902 of the Federal Rules of Evidence provides that a public document bearing a seal is and a signature that attests to that document is authentic and admissible in a court of law. And then there are other rules that recognize that public records such as birth records or also abstracts, which is what these certifications are, abstracts of public records are valid and admissible in a court of law. When we point this out to them, though, they don't. I've pointed this out so many times on so many blogs. What happens is, if these are moderated blogs, they refuse to post them, and if I do post something, it gets deleted. I can't tell you how many countless comments I have made giving rules, giving regulations, giving citations to authorities, and explaining this to Orly, to others. They don't want to hear it. They want to ignore the reality. They want the discovery aspect of litigation. They don't want the rest of it. And
right.
There's a reason. Occam's razor is, and you know, really the basis for that rule, these rules in the federal rules, is the recognition that the simplest way to authenticate something is to have a public official certify it. It makes all the steps necessary to get from point A to point B. You know, it eliminates those steps because it says the word of the state of Hawaii is good enough.
Well, that's right, and if you don't, you can't run society without some rules like that. You know, for someone like Pleric or whatever his name is to get on a blog and state absolutely that from that photo that this document is fake, when multiple times officials from the state of Hawaii has said this is an authentic document. And then they start picking that apart, saying, well, they didn't say that the entire document was true. They said this is the real thing. This is an official document. The document shows Honolulu as a place of birth. So, you know, they have to pick apart statements like that because it's really all they have. And of course now you could see this coming if you watched it. I think it's sinking in to most of them that Obama was really born in the state of Hawaii, and that they're not going to be successful pushing this false claim that he was born in Kenya. They know that those are not going anywhere. So now the line of attack, and you've really seen it come on lately, is, well, yeah, he was born in Hawaii, but he didn't have two citizen parents, and that's what natural born citizen really means. And of course, they've drug out this poor fellow. They've resurrected this Amir D. Vattel. If I'm pronouncing that wrong, forgive me, Mr. Vattel, but he wrote a treatise or a book called The Laws of Nations about 20 or 30 years before the American Revolution. And in one of the passages, he seems to say that he talks about citizenship and seems to say in one translation that natural born citizen means that born of two citizen parents. Well, that's not what was common in British law, which is what, even though we fought Britain, the people, the first Americans were all British citizens before they were American citizens, and most of the Constitution is based on British law. But, we all listen, well, I won't say we all, but we all suffered through Ken Dunbar on Ed's show last week, harping on this, on D. Vital. And I thought, before it was over, I thought, my gosh, I didn't realize that George Washington wasn't the father of our country. It was Emir de Vital. And I'm wondering, wait a minute, I've been to Philadelphia. I've seen the Constitution, Independence Hall. I didn't see a statue of Vattel in there anywhere. Has anyone seen his statue? Were his words emblazoned into the Constitution? To me, every law passed since the Constitution, and almost every the court decisions I've read about only recognize two classes of citizenship. And this argument's going absolutely nowhere. It was plus, on top of all of that, that was the basis, I believe, one of the experts here can correct me, of the case that Donofrio was trying to bring. He was arguing that, Obama was born in Hawaii, but that's not what the natural-born citizenship argument or clause means. Well, the Supreme Court had a chance to hear that case, and they did not hear it. If it were ever going to be litigated, that was the time. So, folks, this has gone to the courts, and it's been turned down, and it's not going anywhere.
One thing that Ken Dunbar, who fancies himself to be a legal scholar, does not seem to understand is that Europe has two different systems of law. There's the continental legal system, which basically is an outgrowth of the Roman system, what we call the Romano-Germanic body of law. And then he was writing, basically, Vattel was writing Law of Nations, which was basically his take on the Germanic legal code, and specifically that aspect of the legal code which related to international relations, not necessarily domestic affairs. But Britain developed a totally different system called the common law system, and that is a system that our courts have recognized is the foundation of American law in 49 of the 50 states. If the states could determine citizenship, arguably Louisiana would recognize de Vattel, but we are based on a British law, and it has developed. We basically took the British law and we simply adopted it as our own, and numerous courts have recognized that, including the Supreme Court. One of the things that Dunbar seems so proud of himself is that he has found this so-called letter by Jefferson, and seems to think that there's some kind of special meaning to that letter. What Jefferson was writing about is he was actually describing to a friend the inheritance laws of Britain. So he was not even attempting to describe American law. Certainly our founding fathers were aware of de Vattel because they had classical educations. They had very liberal educations, which included understanding and reading things in their original Greek, in Latin, in English. And so they were familiar with the works of a number of classical writers. That doesn't mean, though, necessarily that was imported into our Constitution. And so all these people who fancy themselves to be these legal scholars really aren't. What they need to do is read up on those who are really scholars of our Constitution, typically law professors. And, in fact, the University of Michigan Law Review last fall dedicated an entire issue to election issues, and not one true legal scholar has ever suggested that there is a three-tiered citizenship.
Yeah, I think that's a complete invention that has come up because they have nothing else. It's, as I said, it's getting to be the last line of defense, since their whole conspiracy theory about the birth certificate really fell apart a long time ago. I won't say it's falling apart. It's fallen apart. It's gone. Obama was born in Hawaii. We know what hospital he was born in. they celebrated his birth. I've heard that one too. Well, no hospital will claim him. Well, first of all, people want, that's the other thing that ticks me off. People want records released by law or private. And the other thing I hear all the time is, well, why doesn't he just, they whine and whine and whine. Why doesn't he just release his birth certificate? Well, something people are forgetting. First of all, they are greatly fantasizing about how large this birther movement is or how seriously anyone actually takes them. I don't think Obama does. I think he's aware it's out there. Obviously, a few weeks ago when Robert Gibbs called on the crazy guy from World Nut Daily, I've forgotten his name now, Lester somebody, I think he may have known that question was going to be asked and was going to address it. So they know they're out there. But the point is, when you're in a public position like that, it's a case of the more you give him, the more he'll want. And there's no reason at all in his position to spend one more minute, one more second, or one more dollar on this issue that needs to be spent, because it's so low on the radar screen of things of importance to this country that for him to spend more than the minimum amount of time, or even his attorneys, is doing a real disservice to the country. Because, let's face it, it doesn't have to do with the problems that are facing us out there today. You know, This thing about dual citizenship is phony. The United States has never recognized that a person who holds, or seen that a person who holds dual citizenship is any less of a U.S. citizen than someone who's never held dual citizenship. That's a bogus argument from the get-go. So anyway.
Well, they seem to think that allegiance to a nation is sort of passed along by DNA. That if you're born with dual citizenship or even triple citizenship, then you have some kind of allegiance, and that sounds to me like it's almost like biological in character. So, someone has pointed out we have some outstanding people who blog on one of the sites, politajab.com, and including some paralegals who do a lot of great research. And I just wanted to do a shout out for Little Brit Different. And she has pointed out to me, because on the basis of her research about DeVitel, just to backtrack a little bit, that the Supreme Court of the United States has cited Blackstone's Commentaries, which is a treatise which gathers British law, the British common law, more than 800 times. And in contrast, Vattel is cited 189 times. And I can recall, I did some research on that too a couple months ago just to see how many cases came up. And most of those cases citing Vattel relate to boundary disputes between states, primarily where a river forms the boundary between two states. And when the river changes course, the question is, where does the boundary lie? At the old river channel or the new river channel? And that's where the court will look to Vattel. But the court has never looked to Vattel to determine what it constitutes a natural born citizen. And I thought that was a great point that she makes. That she has actually tracked more than 800 cases citing Blackstone.
Well, that's cool. Great point. We appreciate you bringing that up.
Jim Dunbar over at Ed's place wouldn't like that.
Dunbar wouldn't let us say something like that.
No, you'd be off the air in a hurry saying something like that over there. By the way,
that would call for a flush.
Yeah. By the way, there are a few people actually in the Blog Talk Radio chat room tonight, so I think we have more people listening, and I doubt it's the actual one, but someone has actually identified himself as Phil J. Berg in the other chat room there. So
maybe they'll call in.
Yep, yeah. Sure.
I'm going to get off the line and let some others. I'm going to get off the line and let some others call in. And so it's been great talking with you, R.C.
Right. Hey, thank you very much.
Probably catch up with you at your next broadcast.
Okay, next Tuesday night. I guess that's the 16th. We'll be on, and we're trying to work to get a very, very special guest, but let's just say I'm doubtful. But we'll see. Thanks much for calling in. You've added quite a bit to the show, and you're welcome anytime.
Bye now.
Bye-bye. Bye. Okay. All right. Mr. Realist from New Mexico, thanks for calling in. Enjoyed it very much.
I enjoyed it as well, and I'll be back if that's all right.
Okay, sure. You're welcome anytime. And, yeah, we've got about 9 minutes left here. We'll just wrap things up. And, again, I appreciate you listening. By the way, we've been actually, I get the statistics on Blog Talk, and we've had quite a few people downloading the show, so somebody out there is checking it out. And
yeah, we'll probably hear about it on the birther sites tomorrow. So
I imagine the word's going to get out. The word's going to get out.
That's
and,
great. Maybe you'll get some
welcome.
callers.
Sure, they're welcome. They're welcome over here anytime. We'll treat them.
I'm going to hang up and let you have it.
Okay. All right. Thanks. Good night.
You bet. Bye.
Okay. All right. If someone would like to call, we've got lines open. The number is 347-324-5546. Got about 9 minutes left. Time for a quick call. Let's see what I had. Oh, darn! I had two more items here. But again, I'll just state again that on this 3 classes of citizenship, if the founding fathers thought that was so important, where is it in the Constitution? Where is it in statute? Where is it in the constitutional amendment? And where is that statue of Mr. Vattel in Constitution Hall up in Philadelphia, in Independence Hall? I'm just not seeing it. I've seen other people's statues there, but not Mr. Vattel. So let's see a couple other items which fits into it. So, something I've been kicking around, is I'm waiting for the apology from the birthers. I really am. They've made a lot of claims since this thing all started last fall. First of all, they claim that, they made all the claims we talked about Obama and his conspiracy, none of which have turned out to be true. They've told us that, first of all, that the more than once that the courts were going to step in and stay the inauguration. They were going to, that the electors were going to change their minds, that someone was going to speak up and Congress was going to stop the election, the certification of the electoral vote. I've heard all these claims that turn out to be false. I've seen multiple lawsuits. I think if you listed all the birther lawsuits that have gone down in flames or will go down, some of them are still kicking around in the courts. The record so far is kind of over. It's over whatever, at least over a dozen, maybe over 20, and none of them seem to be headed anywhere. So I'm just asking, hey guys, and ladies, it's time for an apology. You've said a whole lot of things that were wrong, and continue to be wrong. So as one of the 69.4 million people out there who happen to vote for this guy, I don't think he walks on water. I've disagreed with some of the things he's done, but he was our guy. We voted for him, and by golly, you're trying to get him out of there, and on nothing. So I'd just like a little apology for what we know you've said turned out to be wrong. It doesn't have to be anything elaborate, just a little apology on your blogs would be wonderful, and I'd have a lot more respect for you if we'd see some acknowledgement like that, on Worley's blog and on whatever Phil Berg's blog is. I don't keep up with them. How about Phil over at the Right Side of Life? A little apology would be pretty classy, but I guess we won't see that. I'll be impressed if we do, though. So thanks much for listening, folks, to our third show. Again, we'll be back next week, same time. That's 9 Eastern Time, Eastern Daylight Time for you people in Arizona, and I think Hawaii that still don't go on Daylight Time. And to be precise, it's 0100 UTC or GMT, which doesn't go on daylight savings time, except you have to go to the next day, so it'd be Wednesday on that time. We'll be back on next week. Maybe we can line up a guest for next week. I've got a couple possibilities in mind, and we'll see if we can line it up. So thank you very much for the folks of you connecting and tuning in. Thanks to Georgetown JD, who called in and certainly educated me a lot on tort law and what's involved in the the Berg v. Tates case out there. What's up with that? What they should be doing and probably won't do, and what the courts can do. Lots of things to talk about here. We don't even have to talk about birther stuff all the time. There's a lot of other interesting stuff going on out there. There's I could talk a long time about the Minnesota recount. That's been a really interesting thing to follow. I don't know whether any of you have ever logged into the uptake.org. They did just a wonderful job covering that recount, the contest trial. It was very fascinating to watch that. Of course, they're progressive, and they were one-sided, but I thought they were very fair in the way they presented that. And there are a lot of really sharp people on that blog too that were commenting. So I don't know whether any of you followed that. Of course, there's a lot of things going on out there in the world. Obama's, we didn't talk last week about Obama's speech in Cairo, what's going on in the Middle East with the continuing wars there. Of course, there's the economy, which is the big story here. I hear some of the news lately is improving. We sure hope that's true. Unemployment is 9.4%. They say it might hit 10. We hope it doesn't, but there's some good signs there. So lots of things to talk about other than this birther topic, which I know some of us probably on both sides have been too obsessed with, but it has been fascinating. So with that, we'll say good night. Thanks for the callers. Thanks for those folks that tuned in, and we'll try this little thing again next Tuesday night. So long. And no one has named this tune yet. See you next week.